Good afternoon, Florida U Judge viewers. We are minutes away from having a segment with attorney Robert Eckard, who will be discussing the current status on the Michael Flynn case. There's been, as of a couple of days ago, there's been a new development on that case, that much reported on case. And good afternoon, attorney Eckard.
Good afternoon.
How are you?
I'm doing wonderful. Thank you. Thank you for having me on.
Of course, always, brother. Always. We will be starting at 2:15, and we will be taking live call-ins at 813-221-9700. To 19700. We'll be starting in 4 minutes at 2:15 with attorney Robert Eckard. Robert Eckard practices in the area of federal criminal defense, state defense. He practices internationally in the area of in those areas, and he also practices civil litigation in the areas of business and non-compete agreements and trade secret litigation. You will be able to call in at 813-221-9700 in the next hour, and you will be able to directly ask him questions regarding the subject matter of this afternoon, the current status of Michael Flynn's case. Two minutes away, we'll be starting today's program on discussion regarding Michael Flynn and the current status of his case. Attorney Robert Eckard is with me, joining me today. Haiti Oropesa for Florida U Judge, and he's going to be taking your calls. You can call in as we're discussing this very important case today, and issues that have recently arisen in relation to that case. Michael Flynn, prosecutorial misconduct, separation of powers in our country. 813-221-9700. You can call within the hour, and Robert is going to be taking your questions. Okay, Haiti Oropesa again for Florida U Judge. It's 2:15. We're going to go ahead and get started. I am trying to send out this afternoon's live stream to some of my colleagues locally. Thank you again, Robert, for taking the time out to discuss this. You tagged me this morning on a major headline regarding Michael Flynn, and most of the country has been following this case. So just give us a little bit of background, and then we're going to go right into the new development regarding this case.
Well, Haiti, I first want to thank you for having me on the show. You're very persuasive. I think you could probably sell a screen door to a submarine salesman or submarine captain. You're very good.
Thank you. And you know what? One compliment deserves another one. I don't say this gratuitously. You haven't paid me any money, and I don't say this easily for anyone, towards anyone. You are, I think, top notch, one of the best attorneys, I would say, in the country, in the world. I have immense respect for you. I am blessed to be able to call you my mentor and a colleague, and I don't say that just for anyone. You deserve that, brother.
Wow, that's
you deserve that.
Coming from you, such a zealous advocate. I appreciate that. Thank you. Well, I'm pleased to have the opportunity to speak about the latest developments in the Michael Flynn case and to discuss some of the latest issues that have been surrounding that case. And just to give the audience a brief update or remind them of what the Michael Flynn case is about, that Michael Flynn was charged with lying to the FBI about his discussions with a Russian ambassador regarding sanctions imposed on Russia by the Obama administration during Donald Trump's presidential transition. Now, he pled guilty in December of 2017, but in January of 2018, he thought of 18, he sought to withdraw that guilty plea, accusing prosecutors of acting in bad faith. So that's kind of what the news is about and what this case is about now. Right now, the judge in this case, Judge Emmett Sullivan, as some of our listeners may know, and certainly this case should have immense and immediate impact and importance to all of us in the criminal justice system. Because what we have here is we have a U.S. district judge who has refused to accept the United States government's Department of Justice motion to dismiss the case against General Flynn. And in doing so, went out and essentially hired his own lawyer, a former judge who I happened to appear before when he was a federal judge, Judge John Gleason, out of the Eastern District of New York. Judge Gleason left the bench and went into private practice. Some of you may recall Judge Gleason, his history as being a former assistant U.S. attorney who prosecuted John Gotti. Judge Emmett Sullivan hired Judge Gleason to essentially step in the shoes of the government when the government and the defense all agreed that the motion to dismiss should be accepted by the court.
Let me stop you there. Is that an aberration? Is that odd? Is that totally left field?
It is not only an aberration, Haiti, but not a single case authorizes an Article III court to scrutinize the decision-making process of the Department of Justice. Not a single case.
Ever litigated?
No.
Ever precedent? Nothing. Come down.
There are cases in where a Rule 48 motion is filed for dismissal, and the court has to look at whether the public interest is served. And certainly there is no case under the facts of this case that has ever been stood the test of allowing a federal judge to deny that motion. Never. No case ever. So what we have here is the Judge Sullivan essentially having Judge Gleason act as the court's lawyer, and the D.C. Circuit, in a split decision, 2-1, said to Judge Sullivan, you must dismiss the case. Judge Sullivan then taking the time that he needed, decided to take an appeal and ask for an en banc ruling of the
Let me ask you
entire.
this. Let me ask you this. Is he being partial?
Is he being?
Because it appears is there an appearance that he's showing bias? Maybe. What I've never seen a judge do this.
I think there's a clear indication of bias. In fact, if you can liken the lawyer who wrote the brief, the amicus brief for Judge Sullivan, former Judge Gleason, the lawyer is the advocate for the client. So by analogy, Judge Gleason would essentially be advocating for his client, Judge Sullivan. And in 2010 or 2011, in a Washington Post article, Judge Gleason, in fact, displayed his bias for this very type of scenario, where the judge could, in fact, deny the government's motion to dismiss. So I think there is a level of bias here, and I think the D.C. Circuit said that. But now, as of Friday, July 10th, the D.C. Circuit put its order on hold, or ordering Judge Sullivan to dismiss the case. And now the defense has, I believe, until the 23rd of July to respond to whether an en banc panel should be gathered to hear the judge's position.
So what does he want to? What do you think? Because you're more up on this case than I haven't been following it as closely as you have. But why does he want to intercept the end of the prosecution of Michael Flynn?
His motivations, I think, are a little unclear. However, I believe when he accepted, I think what he thinks is when he accepted the guilty plea from General Flynn, that was in fact sufficient to warrant look behind the curtain a little more to determine whether in fact any impropriety occurred. Now remember, post-plea dismissals are not uncommon. I should say they're not uncommon for the Department of Justice. I have a whole list of cases that some may recognize as popular or very well-known cases where the government has dismissed charges, and one of them being, if you recall, Senator Stevens from Alaska. Pled guilty, was convicted after a guilty verdict against Senator Ted Stevens, and the Department of Justice revealed that there was suppression of exculpatory evidence. So post-conviction, the government dismissed the charges against Judge Stevens. Another case, United States versus Weber. If there's a substantial reasonable doubt of guilt after conviction, the government can come in on a Rule 48 and dismiss the charges. I mean, I have a whole list that goes on and on where the United States government, the executive branch, has the power, has the rule in their corner to dismiss charges.
Okay, so what you're saying, it's not clear why he's buried his heels in the sand and said, no, I already took a plea. I don't want this to occur. Is it because you said that he saw a little bit in more detail the facts of his case, and what is he in his mind? He's guilty, and this shouldn't be dismissed. Is that what you're saying?
I think maybe he believes there might be some corruption, some suspicion behind why the Department of Justice is doing this in the Trump administration. But guess what?
So does he have a legal basis based on that to move to have this under appeal now to prevent it from being ultimately tossed?
In all due respect to Judge Stevens, he thinks he does, but of course the D.C. Circuit said, no, you don't, not under these circumstances. If
are there any circumstances that you can see?
If there's suspicion of, yes, if there were suspicions of corruption, and there was evidence of such, if there was, let me see, if there was evidence of, hold on, bear with me.
Absolutely. Take your time. The call-in number is 813-221-9700. We kind of did this a little early today. We decided just like spontaneously in the morning, as soon as Attorney Eckard tagged me in the morning about this major headline. I decided let's go ahead and do something this afternoon to discuss this important headline. So, but the call-in number is 813-221-9700. After this is over, it's going to remain on social media as a pre-record so that you can hopefully, if anyone wants to reach you later, Robert, at the end, we're going to go ahead and give the viewers your number, your office number. But there are important issues that now I'm thinking about, because I'd really like to know if there's any. We're talking about separation of powers, right? So
your question, Haiti. Sorry to interrupt you. Your question,
no. Go right ahead. I interrupt too.
Your question is: are there any grounds on which the judge could do this under
right?
I guess a Rule 48 dismissal? Because the district court's power under Rule 48 is severely cabined to clearly the public interest, meaning the prosecutor acted in bad faith, such as bribery, fecklessness, which is a reckless disregard for the truth, animus to the victim, or self-interest. And there must be clear evidence, not contrary imaginings. And so those are the only circumstances in which the judge can inquire as to this. In this case here, it was government file motion to dismiss, case over, everybody goes home.
Right. And so and so now there's an appeal, but there's no evidence that has been presented based on what you just recited that would allow perhaps the judicial branch to move and say no, because there's corruption of some sort.
That's correct.
Okay, very well. So that's the only thing that so far we know, and we're hoping to inform the public, especially persons out there who are have been investigated. Maybe one thought that I have is because locally here we have a sitting state attorney, Andrew Warren, who recently created the wrongful conviction unit. And so after someone's been convicted and the appeals process has been exhausted, they have another bite at the apple, because this is something that some progressive or state attorneys, understanding that sometimes there are wrongful convictions, they're giving another opportunity at review. And if so, they find out that there's exculpatory evidence. And let's talk about prosecutorial misconduct. We understand Brady, when prosecutors hide evidence, information that is exculpatory in nature, or it could be, or impeachment evidence. They hide it because it's all about winning for them. It's not so much about justice. And then they uncover that, they discover it after an a conviction and an appeals process. They go back and tell a court, we want to move and have this dismissed. Under those circumstances, that would be totally not legal for the judicial branch to be able to intercept that. Yes?
Correct. I mean, regrettably, our criminal justice system has become a conviction machine, so much so that I believe innocent people are regularly compelled to confess.
Talk about that, Robert, because you know what? That is true. That's true. The other day I was on an ACLU panel and somebody asked the question, why is the state attorney, why are prosecutors so powerful? I see it. I've been practicing criminal defense now for 20 years. And you know what? Sometimes people take pleas, not because they're guilty, but because they're scared of what can happen. So let's talk about that.
Yeah, the prosecutor dictated plea bargain system by creating such an inordinate amount of pressure on defendants to enter into plea bargains. It appears to have led to an inordinate amount of guilty pleas by people that of crimes for that which they did not commit. In fact, Jed Rakoff, a very famous judge, wrote a book called "Why Do Innocent People Plead Guilty?" I I just recently defriended someone on my Facebook page for insults to me without understanding who I am or what I do, because he felt as if Michael Flynn, General Flynn, by pleading guilty, therefore must be guilty, without understanding that Flynn was under enormous pressure because of the potential that they were going to indict his brother also. So it's another way that prosecutors sometimes use this hammer, if you will, of we're going to indict your wife or your mother or someone else close to you unless you plead guilty, right? So
we're going to give you an enormous amount of prison time if you lose. If you don't, if you go to trial and exercise your right to a trial and lose.
Right, the trial penalty. Right. It's well known. So in this case here, just recently, the United States Justice Department produced at least 14 pages of documents that included Brady evidence that was not previously provided to General Flynn. They provided notes from Strzok and Page, two of the FBI agents that thought that this was a political witch hunt, and identified the statements by Flynn as not being material to lying. They thought that General Flynn was open and honest. None of this was previously provided to Flynn's counsel. And obviously,
why do we let the country, our prosecutors, get away with that? Why is there no real consequence when prosecutors do that? Why do we as a nation allow that?
I think there should be some change in policy, Haiti. I think you've touched upon a hot button. Of course, there's prosecutorial immunity. There's the thought that we don't want to chill the prosecutorial's discretionary function and certainly expose them to liability. But I think Congress or the legislature could act in such a way that if they found a prosecutor engaging in such deceit, that there should be that immunity should be qualified. But getting back to the Flynn case and Judge Sullivan, we would severely question a judge who said, "I'm not going to apply that statute to this case because I don't like it. I don't like the law, right? I don't think it's a good statute." So on the converse, that's exactly what Judge Sullivan has done here. He's essentially said, well, I don't like the fact that the executive branch has the absolute discretionary right to bring charges and to dismiss charges. So I'm not going to follow it. So I think that there's a severe gap in logic when the judge refuses to do what he's done in this case. And I think Judge Flynn's lawyers have done a great job. Sidney Powell, who wrote this book, and if anybody has not read it, I suggest it's a great book. I don't make a dime on it, but it's called License to Lie, and she represents Judge Flynn. And in this book, she calls out federal prosecutors, federal judges by name.
Wow.
Yes, that have engaged in conduct that borders on and crosses the line of corruption.
Good for her. How many people do that, Robert, in our world, in our profession? How many attorneys are bold enough, love justice enough to do that, to call out judges, even defense attorneys, that it's just about money and not doing the right thing? You know, now we have this whole thing in our country about, we get indignant and horrified and repulsed by watching an officer kill a black man unjustifiably, right? And then the thing is now, if that, the mantra is out there, not all cops are bad, and I agree with that. But if you stay silent when you see something wrong and don't say anything about it, you are complicit in that. Would you agree with that, Robert?
With the proposition that lawyers are afraid to identify and call a spade, or at least call out a judicial officer for conduct that might be improper,
or prosecutors.
It is. I mean, you're always concerned about your next case, right?
Right. Money.
I mean, so you get into it with a prosecutor on one case that hopefully doesn't define your career or their career, and somehow you're then tainted for the next client,
And
right?
you know what? That's why you're here this afternoon, because the truth is the truth. And I'm not going to I'm not going to praise anyone of a colleague, an attorney. You or have earned my respect, Robert, because you are that type of attorney. You are incredibly respected, and you're a badass. That's you.
I'll take that as
You
a compliment.
it is. It is. You are. I admire you. I admire that. I'm gonna read that book. Say what the title of that book is again. License to Lie.
Yeah, License to Lie by Sidney Powell.
And that person represents Flynn.
She represents General Flynn, correct? Um, and so I think lawyers have a duty, Haiti, to as you have done, respectfully. I mean, this is, you can pat me on the back all you want, but you're in the same you're in the same tent I am. And when you see misconduct by prosecutors or judges, you're not afraid to call it out either. And I think we have a duty to do that, a duty not only to the system that we're part of, but to our clients. And many times when we do that, we get the scorn of the judge, and sometimes I've seen judges file grievances because of their disdain for lawyers, which is
Listen, is there a conflict of interest when an attorney decides I'm not going to go as hard as I need to go to properly and zealously and effectively represent this client because I don't want to piss off the prosecutor or the judge? Isn't that a conflict? Shouldn't you conflict off that case if you're more concerned about continue your gravy train rather than effectively and zealously represent your client? That shouldn't be a consideration. And if it is, isn't that a conflict?
I think it's a conflict in terms of you're trying to protect something you believe is in your best interest as compared to what's in the client's best interest. So if you're withholding arguments or not as zealous as you would not otherwise be or would otherwise be, then I think maybe you ought to reconsider your profession. I mean, this litigation is a full contact sport as long as it's done ethically. Unfortunately, we have, for the great majority of judges, apply the law equally and have the right temperament to sit in that very privileged role on the bench. Many of them were friends of mine before they became judges and are friends of mine now and are very well respected. And of course, it's the 90-10 rule or the 80-20 rule, where you see 10% or 20% of a profession that gives the other 80 or 90% a bad name.
But we do have good judges, and we name those out too. And we have good, fair prosecutors that have ethics, and they want to do. Listen, it's not about winning. Sometimes we lose, and it's fine when everyone's doing what they're supposed to be doing ethically and following the law. At the end of the day, it's the citizenry. They represent us, our government, the legislature. They legislate our will, right? And judges are supposed to follow the law. That's it. Uphold it. That's what they swear to do. And the executive, they're supposed to enforce it. If everybody's doing what they're supposed to do with ethics and seeking truth and justice, we should all be good, even if we lose every now and again. It's fine if those ideals prevail and are upheld. Yes?
Well, that's why the statute of Lady Justice is blindfolded, and unfortunately, we run into those instances where the judge may have taken the proverbial blindfold off. And listen, I'm not saying anything that no one on this program has experienced or hasn't heard before. Where defense attorneys, zealous defense attorneys, gather the scorn of a judge because of the job that they're doing. Some judges. Now,
Right.
I'm not suggesting that this is a problem with every single judge, but even one judge, Haiti, it's a problem, right? I mean,
Yeah.
In this country, I've told my children, the government can take your life, they can take your liberty, and they can take your property. They can take all three of those things from you, so long as they give you due process. And who determines due process? Mainly, it's the court system, right? And so there's great respect for the judiciary.
Yes.
And when they become when lawyers become part of the judiciary, they have a great, they stand on the shoulders of giants, of others.
You know what, Robert? Today, a lawyer who was a classmate of mine in law school. I'm not gonna say her name because I don't know if she'd be okay with me doing that. But she reached out to me and told me, because I have taken it as a civic project for some years now to have some accountability on the judiciary. Why? Because oftentimes the voters don't, in state court, they're appointed in the federal system, but here in state court, they're elected. So she reached out and said, my son's he has his ballot. He's going to be voting for judges here in the Sixth Circuit. Who do you recommend? Because the voters need familiarity. That is the role of citizens. They should be following who is serving on the bench because of what you just said. They have the ability to impact our life, right? Liberty, property, right?
The great majority of citizenry, Haiti, I agree, doesn't come in contact with judges. And so you're right. Lawyers are often asked by folks that don't know who might be on the ballot or whose name appears on a board that's on the road, if they should vote for this person or not. So lawyers are relied upon, and I often get the same calls. Who should I vote for? We're the ones that appear before these people and these judges, or if they're not a judge yet, how were they as a lawyer? And I think it's important for us to educate, again, as you're doing here, to put. We all want judges on the bench. You talk about the application of the law, but we want application of the law equally.
Right.
And so many times, it's disheartening when you see or experience a judge that is more pro-prosecution than being neutral. If anything, they should be more pro-defense, because the defendant is the one presumed with that presumption of innocence, right? I mean, if there's a tie, the tie goes to the defendant, right? So
you know what? And I'm going to speak about this too. Listen, it's great. You're well respected. You are very well respected, not only with the public and people seeking you out for representation. I'm not trying. This isn't a commercial for you, Robert. This is the truth. If I got in trouble, you'd be the first person I'd call. Honestly, I completely trust your ethics. Your ability. You are ferocious. You are a pit bull. But so you're very well respected, but we don't necessarily, I don't want to be treated with favoritism. I want equality for everybody, for every lawyer. And I see that sometimes when a specific judge is kind of friendly towards one, and there's that appearance too. That shouldn't be. Everyone should be treated equally. That's justice.
I agree that people should be treated equally under the eyes of the law, Haiti. I guess what I was referring to is if there's the issue of, and we're talking in this instance of the criminal justice system, that we know that the primary purpose of the criminal justice system is punishment, but we also know that it has to be tempered by mercy. And so I'm not going to go through a list of names of judges who do that every single day. Remarkably, at least here in the state and federal system, that I have tremendous respect for. And they know that I'm always in their corner if for some reason they draw an opponent for election time. I support, as do you, judges.
Good judges, absolutely.
It's
Yes.
it's so important for all of us, for the system. Listen, it may not be the it may not be the best system ever created, but it's the best system in the world that we have here in the United States. I mean, I practice international law, and we have jury systems here, which is a rare thing throughout the rest of the world, and almost non-existent. And so the Constitution in this country that is applied every day in courtrooms across America, to people that don't understand what they have here, it really is remarkable. And I'm speaking from experience. I've been to Russia. I've been to Cuba. Okay, I've been to countries that
you're a globetrotter for sure.
I'm often in Colombia, Panama. So I've crossed into these different legal systems, and what we have here is certainly appreciated by me as a lawyer.
And listen, I think you share this sentiment that I'm about to express. I, here in the Sixth Circuit, even when in the 13th Circuit and surrounding counties here, I think the majority of judges I respect, and I think they're good judges. Do you agree with that? Most of them?
Absolutely.
Yeah. So this is, when I first started with the survey, people thought, oh, is this about judge bashing? Absolutely not. I can seriously say I've been practicing here for like 20 years, and most of the judges, I have incredible respect for them. I do, and what they do. And so when, like you said, when they're challenged, if they're doing a good job, and elections and challenges, that's always a good thing. So to keep them knowing that that is the seat of the people. But I honor good judges. I do, and I recognize them. But when we see something that's not right, we're in the best position, attorneys that are in the courtrooms day in and day out, to point it out.
And Haiti, with a few very limited exceptions, I'll say this: at bar functions or other functions, we might have the opportunity to talk to judges here in the Sixth Circuit or the 13th Circuit or any other circuit or the federal system. Most of the judges that I speak with and talk with say, if you hear of anything that is causing a problem or that I could do better, I don't know any of them, with a few limited exceptions, that don't want to know that information and certainly improve their ability to be better judges. I mean, it's just like how can we be a better lawyer? So they take that constructive criticism with wide open ears and opportunity to be better, and I appreciate that, and I think that's what makes them good judges, right?
You're right. Humility, that's a virtue, because sometimes they're and I was meaning to ask you when we were going back to the Michael Flynn case and the judge that doesn't want to have the case, the prosecution or the case tossed. Should this judge disqualify himself? Is there an ability for somebody to move to disqualify him? Because there is an appearance of bias, because there's nothing that this judge has presented that would serve as a basis to have a meritorious claim or argument that it shouldn't be dismissed because there's some corruption or something that would prevent it from being dismissed.
It seems like there would be a viable motion there, but not having a complete understanding of the record. I can't really comment as to whether there would be grounds for recusal based upon Judge Sullivan's legal belief under Rule 48 of his right to not accept this motion to dismiss by the government. There are certainly no grounds to have his own lawyer as he did. It's unprecedented.
Okay, so that you've never seen that before.
Never, nor have I.
For a judge to get an attorney to fight his position of not having the case dismissed.
Never.
So isn't Yeah, that is a little bit odd. Like, wow.
Right. He's representing.
He's a party in his own case.
Essentially,
Is
he's
he a judge or
representing.
is he a litigant?
I mean,
What is he two people? Like, what's going on here?
well, the DC Circuit agrees with us. So I don't think an en banc panel is going to change the outcome of this. So we'll have to wait and see if it even gets there.
Okay, Robert Eckard, he practices. Well, tell us where you practice. Tell us everything that you do, just to remind the audience, those who are coming in on the tail end of this broadcast, 813-221-9700. You can call Robert live now and ask him questions or weigh in on the discussion that we're having. Tell us, Robert.
So I practice.
How can people reach you?
Well, my phone number is 727-772-1941. Again, 727-772-1941, or Robert at roberteckardlaw.com. I practice business litigation, which includes intellectual property litigation, non-compete litigation, trade secret litigation, shareholder disputes. I've practiced securities fraud. I've handled cases against the Securities and Exchange Commission, cases against the Federal Trade Commission, cases against any government agencies. So my practice also includes defense and government investigations. It could be criminal with the Department of Justice, U.S. Attorney's Office, Office of Foreign Asset Controls, or it could be a business litigation case. And sometimes we have parallel cases where you'll see a securities fraud case and in addition to with the SEC, and you'll have maybe a bank wire or mail fraud case or securities fraud case in the criminal context by the Department of Justice. So those are my practice areas. I also practice international law, often traveling to Bogota, Medellin, Cartagena, international narco trafficking defense and money laundering. Often work with agents from the Panama Express DEA task force and other task force 959 out of Dallas, or other agencies that are enforcing the narco trafficking laws. I have cases from Boston to Los Angeles to San Diego to Bogota.
Well, what state are you now working to be admitted to, in addition to all the states that you are currently admitted to?
Well,
practicing in this country.
Huh? So I've got 12, I think 11 or 12 continuing ed hours to complete, and I'm going to be admitted into Texas. That's my next jurisdiction. So
okay, what states are you admitted to already?
I've just full-time Florida and Washington, D.C., but I've been pro-hocked into California. I've pro-hocked into New York. I've pro-hocked into Texas. I've pro-hocked into Delaware. I've pro-hocked into probably a dozen other jurisdictions, both state and federal.
Okay. Well, 813-221-9700. If anyone wants to call, it was a little early that we did this broadcast today, Robert, but you're going to come on as a regular legal commentator, so that I'm excited about that, and so that we can inform the public. It'll be educational. That's my role. I love to do that and get so that the public understands the criminal justice system is a very intimidating place to be when you're not a lawyer, right? So I'm excited about that. Is there anything else that you want to wrap up with?
I want to say that this platform now is, thankful to you, is hopefully going to not only educate lay people, but shed some light on topics that might not otherwise be discussed, and have panels of experts on and people on that can really benefit both sides of the either the political aisle or both sides of the bench and bar. I think it's a fantastic platform to have.
I want to kind of show a couple of comments that have come in during the broadcast. Kimberly DeFalco, somebody that I admire greatly, wonderful human being, this woman. She is a very, very talented photographer. She's the person that you'll see a lot of the amazing photography out on social media. She's the name out here to call for by politicians and activists to take photography. So hi, Kimberly. Thank you so much for writing in and saying hello. And then we also have Leonora Mendiola Adams, and she says, "What a great way to educate people about this practice, as well as to get to know about good lawyers like you. Do you do this every day? I found this so interesting. Thank you. No, thank you, Leonora. Thank you so much. She's an awesome. She has a traffic school out in Tampa. ADES, ADES, a center is her traffic school. If you want to call her. And Michelle Williams, great interview. Thank you, Michelle. Thank you so much. She is. I saw today on her page she's gonna have a live at 8, and I think she might be speaking about criminal justice issues. So you might want to follow her tonight. She has a live at 8. Again, brother, I love you very much. I'm incredibly blessed to have you as a friend.
Let me ask you this, so that
Yes.
that the viewers can, and whether this is an option that they have, are these segments going to be cataloged so that maybe if in the future, if a person has missed this
Yes.
show, they can
Yes.
get on and see it?
Yep. So after the live ends, it will then be left on social media, YouTube, and Facebook as a pre-record. So we're live now, but once it ends, it'll stay on as a pre-record so that people can go back and view it whenever, as long as it's up there. So to answer your question, yes. It was kind of early today. This is the infancy of what our project is going to be as coming on to inform on different topics that we think it will be informative for the public to hear about and related to current headlines. But we'll have to agree on a good time for you and I a little later, a day every week, or how not every week, but every so often when we get to do this because we're both very busy. It was awesome having you on. I'm very excited.
Thank you.
Love you very much, brother, and thank you for joining.
God bless.
God bless.
Thank you.